Hello, and welcome to Season 1, Episode 4 of ARBinBRIEF, a practical video guide on hand-picked arbitration issues. I am Vanessa Zimmermann de Meireles, a member of ARBinBRIEF team. ARBinBRIEF videos, in collaboration with 𝗔𝗥𝗕𝗙𝗏, Delos Dispute Resolution, and Mundi, offer a quick resource to consult on issues that arise in international arbitration, while showcasing talented arbitrators in an interview format. Over the course of the 10 episodes of Season 1, we are moving through the life cycle of arbitration. Having already nominated the arbitrators and held the case management conference, today we turn to the drafting of the Procedural Order No. 1 and the most important and challenging issues to watch out for. I am honored to introduce to you our speakers, both accomplished independent arbitrators. Joining us from Madrid, our interviewee of today is Krystle Baptista, an independent arbitrator at her practice KB International Law and Arbitration. And from New York City, our interviewer is Dana MacGrath, independent arbitrator at her practice MacGrath Arbitration and ArbitralWomen president. For those who are joining us live, the 15-minute interview will be followed by a 15-minute Q&A session. Please send us any questions you might have during the interview via the Q&A function in Zoom. Over to you, Dana and Krystle.
Good morning, good afternoon, good evening from New York. I am Dana MacGrath, and it's a pleasure to be with you today. And thank you to the team at ARBinBRIEF. Thank you, Vanessa, and everyone behind the scenes who makes this fabulous series possible. So I will be interviewing Krystle Baptista, or Arbitrator Baptista, going forward. And we're going to talk about some of the key issues of Procedural Order No. 1. So Krystle, let's start at the beginning. What is Procedural Order No. 1 and what is it used for in arbitration proceedings?
Thank you so much, Dana. Thanks so much. I echo your thanks to the ARBinBRIEF organizers for designing this short program and for inviting us. And thanks to you for being the interviewer of this in this episode. You are such a reference for so many women. I am really honored to be here with you. And going into what the first procedural order is, it is a document that sets the procedural timetable and that establishes the basic rules to conduct the proceedings. So the exact content and nature of the document will be determined by the rules chosen by the parties. Different rules will allow for PO1s with different scopes and with different provisions. For example, if you have an arbitration under the ICC rules or under UNCITRAL rules, which already determine that the parties need to sign a terms of appointment or a terms of reference, then you will have a PO1 strictly limited probably to the two elements that I already mentioned, establishing a calendar and establishing basic rules to conduct the proceedings. Whereas if you have rules that do not provide for terms of appointment or terms of reference, you will probably find yourself having a more comprehensive PO1, which might include also provisions regarding, for example, the constitution of the arbitral tribunal, the parties involved, their representatives, the arbitration agreement, the language of the proceedings, the different rules that are going to apply in terms of both substantive and procedural fees and expenses of the tribunal. Maybe if you're going to name a tribunal secretary, you will want to include that as well. Apportionment of costs, advance of provisions, so different things that might not appear in other documents. And some of you might think, well, this is boring, right? So I'm going to tell you why this document is really important. And basically it is because it establishes the rules of the game. And that in legal terms translates in guaranteeing due process and equality of arms. You need to know the rules of the game in order to play them to the advantage of your client, and also to call out opposing counsel in case they're not following them.
Thank you, Krystle. You made the point that the scope of Procedural Order No. 1 can vary depending on what rules the arbitration is being held under and some other factors. In what category or type of Procedural Order 1 would you say the Delos rules provide? The more comprehensive category of procedural order number 1 or a less detailed one?
So yes, they will definitely fall under the more comprehensive one because the Delos rules do not provide for the signature of terms of appointment or terms of reference, right? Particularly, for example, in the Delos rules, we know that when establishing the procedural calendar, there is a specific provision that would allow the parties to include a pause for a settlement, which is something that you don't see in all rules, and thus, something that you might want to take into account. There's also a provision in Article 12.4 of the Delos rules that establishes a very proactive role for the tribunal, and that specifically outlines the powers of the tribunal. And those powers and the different provisions that are set in Article 12.4 might serve as a good checklist for things that the parties may want to discuss and include into that more comprehensive PO1.
Thank you. So it sounds like Article 12 of the Delos arbitration rules is really important when you are drafting the procedural order number 1 and working with the parties on that, to the extent that it's a collaborative work with the parties. Turning more specifically to the components of procedural order number 1 and the calendar, the arbitration calendar, what types of provisions or procedural events in the arbitration are discussed typically when drafting the procedural calendar for the case?
So normally you would discuss the number and the amount of written submissions, the date, the content, the filing of the submissions, including the types of documents that may accompany the submissions, witness statements, expert reports, the number of copies that you have to present, the method of filing, the rules and the dates for bifurcation or even trifurcation of the proceeding, if that's the case, whether you're going to have document production or not, whether you're going to have a hearing, how are you going to organize it, what about post-hearing submissions, what about cost submissions, and of course, rules on additional submissions.
One question, I don't know if this fits in here, but do you ever find it helpful to incorporate a reference for guidance to soft law rules that are out there for the help either in disclosure issues or other issues? If so, do you put it in the procedural order number 1 or a subsequent procedural order in the arbitration?
Definitely. I mean, for example, if there's going to be document production, I definitely include whether the IBA rules on the taking of evidence are going to be, a reference point for all the parties involved, or whether they're going to rule the arbitration. And this is normally included in PO1, even in cases where there are terms of reference. I would say that since this is a document where you would discuss whether there's going to be document production or not, that would be the place to include whether the parties want to use the IBA rules on the taking of evidence as a guiding point or as the rules for document production. And the same goes for other different soft law that would govern or that would give you guidance on procedural matters.
Yes, I've seen that often as well. So I think that might be a transnational global trend now to incorporate, at least for guidance, if not binding, some of the soft law instruments that are out there. So looking more specifically at the procedural calendar that is part of procedural order number 1, what aspects of the calendar have you found to be most important or helpful to include to manage the proceeding in a time and cost efficient way?
I think one provision that I have found to be very important is that on additional submissions. I think we've all seen 2 tricks being done in arbitration proceedings. One is to surprise the opposing counsel and the tribunal with a last-minute submission. And the other one is to have the tribunal take a look at a document, even if the document is later on not submitted into the file, right? And in order to prevent those 2 tricks, what I normally do is that I add a provision forbidding the filing of any submission, document, or legal authority outside of the timetable, absent, of course, the showing of exceptional circumstances of good cause. And the way to do this type of submission is to request, right? Or make an application to the tribunal, who will decide based on having heard the other party before you can actually file the document, right? Which would prevent, well, the 𝗔𝗥𝗕𝗙𝗏.
So hopefully the applicant only files its application and not the document that it seeks to put into evidence. But I guess it's the discretion of the tribunal as to not look at that attachment if it were inadvertently attached until the decision as to whether good cause has been shown has been decided by the tribunal. I've seen that too, so I think that's an important provision for sure. So what are some of the basic rules or requirements, procedural requirements of the arbitration proceedings that you see typically, or you lay out typically in the procedural order number 1 for your cases?
So as I said before, it will depend on whether we have a comprehensive one or a more narrowed one. But in the more comprehensive one, I would definitely include the calculation of time periods and time extensions, the routing of communications and requirements of filing is transmitted electronically, which is my preferred approach as a signatory of the Green Arbitration Pledge, or how that should be done and when, until what time in the day, what time zone, if that is required, you know, and if they're going to be transmitted on paper, well, how many days after, or the same day of the filing. Then also maybe include the powers of the arbitration tribunal and specifically of the chairman, right? Whether the chairman can sign by himself or by herself the procedural orders that will come after PO1, or whether the entire tribunal needs to sign them. Then, for example, also the language of the arbitration. That's in most cases where I've participated, everyone speaks English and Spanish, and so there is no need, even if the language of the arbitration is only one of them, to have everything translated if they're not in the language, because everyone speaks the language. So you would make sure that that is included. Also, any provisions on recording and transcripts, data security, if it's if it's an investor state arbitration, rules on transparency, amicus curiae submissions, non-disputing party participating, those kinds of issues. So it really depends, but there are some good guidelines that you can look at. There's the ICA, for example. They have a very good checklist for PO1 that I recommend. And although I have my own already set procedural orders that I like to go to depending on the rules that I am using, I definitely like to tailor that to different cases, depending on the needs of the case and what is needed of the parties, and how the parties want to tailor their proceeding, because in the end, it's the parties proceeding and the tribunal is just there to help them.
Well, you've covered a lot there, Krystle. So I'll just echo the shout out to the Campaign for Green Arbitrations, to which we are both signatories, and embrace the digital world for submissions. And also that there is actually a wealth of material out there that you can use as resources for newer arbitrators in preparing their first procedural order. You know, you mentioned the ICA checklist. Other organizations and institutions similarly have checklists, and those can be really helpful, as well as having, when you can, your own template procedural order number 1 that you can tailor specifically to the needs of the parties, the agreement of the parties, and the needs of the case. So all of those components that you listed may or may not be applicable depending on the arbitration, and having guidelines and references is really helpful. So thank you for outlining that. If you could choose one aspect of the procedural order number 1 and/or the calendar that you find to be the most tricky or controversial, what would it be?
Time extensions. I haven't been.
No one requests more time.
Yeah, I haven't been to a case where the parties haven't requested more time. So I definitely include a provision on time extensions. And when I do that, I normally expressly state that the parties consider that the time periods that have been fixed in the timetable are ample and sufficient, and thus that there will be no extensions, except for good cause and upon a reasoned request. And then I always add that time extensions that imply a cancellation of the hearing will only be granted in exceptional circumstances, because it is often very difficult to find dates for everyone to agree on. And once you find them, I do think that the parties need to stick to them. No? This being said, I also make sure that the calendars have some wiggle room to adapt, because we all know that sometimes there is good cause to ask for time extensions, and thus they need to be granted.
Well, thank you, Krystle. That was a very quick deep dive into the components of Procedural Order Number 1. We want to spend the second half of the half hour, so the next 15 minutes, on our Q&A and continue our discussion in that format. So I'm going to turn it back over to Vanessa, who will guide us to the next step of our time together.
Thank you, Dana. Thank you, Krystle, for this insightful discussion. I have noted a couple of tips to keep in mind for my next arbitration, and I see that we have received a couple of questions from our live audience for our Q&A session. I would like to thank our partner organizations, 𝗔𝗥𝗕𝗙𝗙, Delos Dispute Resolution, and Mundi for their invaluable support. Delos Dispute Resolution is an independent arbitral institution established in 2014. We had today one question regarding to the Delos rules, and we were really happy to see the discussion from our speakers. Mundi provides arbitration research tools for lawyers, including a directory of more than 5,000 profiles with arbitrator analytics. And 𝗔𝗥𝗕𝗙 establishes concrete and actionable steps to increase the number of women appointed as arbitrators, with the ultimate goal of full parity. Season 1 is also supported by ArbitralWomen, Careers in Arbitration, and Rising Arbitrators Initiative. For those watching us over YouTube, this video ends here. Thank you for joining us. To see future ARBinBRIEF videos on hand-picked arbitration issues, please follow us on LinkedIn and like and subscribe to our channel on YouTube. We would love to hear your comments and feedback, and you can register to our next episode under www.arbinbrief.com. We look forward to seeing you there.